the two who I placed at but I pleaded for them to accommodate. I also wanted them to
support that application for cross-examination of the officers. As a preliminary issue, we'll want that one dealt with. The fourth issue that is preliminary, Your Honor, is that the Sunday Standard of 30th October 2022 quoted at length the investigating officer's report that the respondent took photos of the dead people and presented them to their bosses. And also another issue is that already their DNA samples have been taken. We'll want to address these questions as a preliminary issue. Though yesterday I heard the Director of Public Prosecution, the head of my good friends here, disowned this. That was the DPP disowning. And because the DPP has disowned, let the investigating officer take to the dock. This thing has caused mayhem.
Hold on, Mr. Man. Don't convolute.
Yeah.
Take to the dock to cross-examine on the affidavit, or what is that?
On cross-examination of the affidavit, and this is story.
No, we will object that.
Hold on.
We will object that.
Hold on.
He's not the author.
Hold on. I'm only relaying issues. I'm only raising issues that are going to be addressed.
Okay.
We have raised 4 pertinent preliminary issues.
No, hold on, Mr. Omari. The issue of the press is what he's raising an objection to. Give him time. Is that part of the reason why you want to cross-examine, or that is simply for the court's notice?
Our application was based on his affidavit.
But not on what appeared in the press.
Now, this is what appeared on Sunday.
Yes.
We have put it as among the issues the court should address to. We put arguments on what we think it is. The state will respond.
No, that is another issue. Let's not convolute issues.
There are only 4 issues.
With respect to the issue appearing in the press, then that one has to be an application on this aside from what is before us. You called the officers to be cross-examined on the affidavit. This one will have to summon the standard. You see, because of the maker.
You know, we have not laid the basis. All that I did was to enumerate it as a question. We'll address you about it.
Yes.
Allow us to address you about the newspaper. Let a ruling come out that call the MD of, but we need, the lawyers need to put their arguments. The defense, the state needs to put their version. The court will make a ruling. No. We have only enumerated 4 items.
A court of law gives direction, and this is the
Nonetheless, Your Honor, we are ready to proceed. And validation, then with your directions, we can be able to move forward and make another appropriate application. Because the defense has made quite a number. But I think for purposes of the court record, Your Honor, we can begin with, as I said, Your Honor, the said application is supported by the affidavit of the lead investigating officer, Mr. Wilhelm Kibet, a senior superintendent of police, and is also dated 27th of October, 2022. Your Honor, the 2 miscellaneous applications are duly filed before this honorable court, and they are duly served on all the 9 respondents present in court today, who are also present in court today. Your Honor, the contents of both applications and their supporting affidavits are self-explanatory. And I will not belabor the court by regurgitating each and every paragraph. Your Honor, on the laws applicable that we wish.
Most probably, we will only allow 3 to deal with the question of consultation.
That is almost half an hour.
3 will. Clifford will lead in that matter, followed by Onge and Shadrach on that.
But that application, that is miscellaneous application number E249 of 2022, is anchored purely on 2 laws. That is Article 49(1)(h) of the Constitution and under Section 118 of the Criminal Procedure Code. Your Honor, that is now miscellaneous application number E252 of 2022 is anchored on Articles 49(1)(g) and (h) of the Constitution under Section 36A and 118 of the Criminal Procedure Code and Section 122A of the Penal Code. On the basis of that, Your Honor, I would like to put it clear that the jurisdiction of this Honorable Court to determine an application is anchored on the law under which the application is brought before the court. Your Honor, subsequently, pursuant to Article 49(1)(g),
The court must be anchored on a specific section of the law. And that is why it is pursuant to section so and so. You are jailed or you are acquitted. So it is our position, Your Honor, the first application, the respondents in that application have responded as per the law in relation to the facts presented by the investigating officer. And the second application, equally the same. We urge the court to make a finding that if the provisions of the law invoked are wrong, the state can withdraw and file a new application. Seek an amendment specific. The identity of 30 days is an identity that will come with a specific section of the law. It can't be an omnibus, that this is a court of law. It is specific. You know, we urge that that is a serious legal question that needs to be resolved before the respondents who are saying they'll be prejudiced. If what they faced under Article 50 and Article 49 becomes a monster that has mutated now to be something else that they are required to lay their feet down against. We urge the court to uphold that any form of trying to justify a section of the law is not found in any law, whether it is Article 159, whether it is whichever provision of the law. That's all.
Okay, I had noticed that in your application, which they have brought to my attention. Now, you are saying it's not a typographical error, but it's an omission.
It's an omission, Your Honor. It's an omission.
So
Okay.
that cannot definitely come up in your response. In your response, you must admit what they are saying.
Yes.
You have to admit.
Your Honor, we do admit. Thank you, Your Honor.
Admit.
We do admit.
Are you entitled to costs in a criminal
We do admit
matter?
and apologize. to our learned.
Admit, I record the admission, and exactly after they have admitted, and now
application which
Embarrassment the state is finding itself to apologize over a document that never originated from the office of the Director of Public Prosecution. That is a document from the DCI, but we understand.
No, I object to that. That's not a document from the DCI. Your Honor, I will ask, I'll ask the lead counsel.
For a further 15 days, it is, with a lot of humility, a jail term. It's conviction. On very summary basis through the bar.
can you propose?
No.
What you think is reasonable for them?
It's okay. I want to sit without making a proposal, and that one will be made will be based on a common sense approach.
Yes.
That we all have gone through law school. Some of us are senior, some of us are junior, but it's okay. Asking for 15 days is not something that the court can countenance. I want my colleague to rise and give the court a reasonable time period, considering that these gentlemen are in custody. They are not sleeping in their beds, they are not going to work, they are not seeing their children. They have the company of my friend behind these cameras who keeps them in custody and ensures they eat government food. Let us be reasonable.
Mr. Oonge, I request one of your team members to propose the days.
I will. Them granted 15 or 30 days or 2 years. So long as they are put on bail, on bond. As we have no problem, the state taking their sweet time. Let them be entered on bail or bond. Your Honor, the 15 days, contextualize it when I raised the question of the 5 police officers who were taken to Industrial Area Police Station, which was actually a death sentence had you not gone there to save the lives of the 5. By now we could be talking of dead 5 police officers.
No, I object to that statement. I object to that statement.
I have with Mr. Samuel.
Okay, let me withdraw the term there.
Yeah.
The court, in its own wisdom, went to the police cells and removed the 5, which is a serious indictment on the investigation side. Today, they are saying we have served them with a question about jurisdiction. We have served them with 9 affidavits. You know, these 9 people have only afforded 5 advocates. 4 of them funded by Sharia Mtaani on pro bono basis. The state bureaucracy where they have been serving has a tune of not less than 2,000 prosecutors. They want 15 days. From the onset, Your Honor, we raised the question of selective arrest, and the purpose is to treat these people with total disregard to their human dignity. You know, we urge this court. What we have raised is a response of what they raised. There's nothing new. Us saying that the accident happened, the scene of crime was at Mombasa Road. The bones were found in Aberdare. Is that something to go and do research? It is them who have told us from the affidavit. There is nothing new we have raised. We have only contextualized their affidavits to the reality on the ground. And therefore, we, on our part, we are ready to proceed. They were ready to proceed. Now we are being told they need 15 more days, which equally comes to the question we are saying. Do they want to keep these people as souvenirs for the media to take their photos and continuously splash, or do they want to prosecute this matter? You know, it is totally unfair to keep people in a cage as zombies, and they were government officers. And I told this court, and I'll continue telling this court, that the state will eat its own when time changes.
I object to that statement, that line of argument, Your Honor.
Not an office. Even me, I'm the state. Every Kenyan is a state. And all that we are saying, Your Honor, let these people be entered into bond. They are police officers. Their records are known. They are serving. There is no evidence from here in this affidavit that there are flight risks.
Oh, they are indeed.
Then let's proceed with this matter today.
Allow me to do
To be guaranteed
and if there is no bail, then the matter has to proceed.
today.
Yes. Okay.
And the request of the 15 days. I was shocked that he made the request without blinking his eyelid. Your Honor, Mr. Omari taught me jurisprudence in the university, and there is a book he introduced me to, written by Ronald Dworkin, Taking Rights Seriously. Your Honor, the people who are seated on my left enjoy some constitutional protection. They are guaranteed, amongst many other things, a presumption to innocence and an entitlement if they are accused of anything. Your Honor, what is before the court is an application that has been made by the prosecution requiring, Your Honor, an order from court pursuant to Section 36A of the Criminal Procedure Code to detain the suspects on my left for a period of 30 days, Your Honor. The record will reflect, Your Honor, they were arrested on the 26th day of October. Your Honor, we are on the eve of the month of November. It's been a week or so days since these people who are entitled to their right to liberty were arrested, detained, and Your Honor, they are living with the hope that ultimately you, as the Honorable Court, you will give directions so that their right to liberty can be redeemed. So that, Your Honor, in all fairness, having been dragged to this Honorable Court by the prosecution, and in view of the constitutional rights and fundamental freedoms that are involved in this case, it only makes sense for us, Your Honor, that we can adjourn even for 10 minutes for the prosecution to lay their case to you. The principles under which this application should stand or fall is documented in law. So that I can even say, for the benefit of the public, that it is even enough for the court just to look at the application alongside our responses without even considering any submission made before the court, for the court to give us directions as to whether it sees any need for them to be continually withheld by the state or not.
Do a consent, and I will come up with that ruling. Can you agree on consent that we consent that the court follows the affidavits and the application and the replying affidavit and come up with a ruling? I would do that.
Yes, Your Honor,
Can you confirm?
Yes, Your Honor, allow me to say this, and I say this quite respectfully.
Yes.
It is important
Yes.
that in the midst of the wheat that the court finds itself in, that we allow the court to see through, and that perhaps should give the court, because we will be assisting the court in determining the application. So, Your Honor, respectfully, and I say this in closing, just allow my senior, Mr. Sang, and team, just 10 minutes or 15 minutes. There is nothing new in the application, in our responses. In any event, it's the application. Let us come and address you on matters of law. Thank you, Your Honor.
Actually, the response.
Further orally to all this, respondent, the 9 of them in total, we need an opportunity to respond by way of a further affidavit, also substantively, in equal measure, Your Honor, so that this court can make a substantive determination in this matter when we will be ready to proceed. When I first addressed court, Your Honor, this morning, I said, I'm ready to proceed. But then again, are being raised. So, Your Honor, being an officer of the court and understanding that this is a court, taking from both counsels, Your Honor, we, the prosecution, have conferred. We understand, and since we are objecting on the issue of bond at this stage, we don't want to be murky and start, arguing on those issues of whether to release on bond or not. What we're asking for is time, and we've reduced it to 7 days, Your Honor. We'll be ready to proceed, and we substantively address the issues here. Your Honor, in Ms. Khadija will also address the court on this matter. Thank you.
To curtail the first respondent who
respond to the replying affidavits filed by the respondents. Secondly, whether the respondents should be released on bail bond in the meantime. At the onset, I would like to point out that the replying affidavits were only served this morning pursuant to the court's direction. As much as the respondents' counsel filed the replying affidavits, they did not serve the hard copies upon the prosecution team as required. The court had not given directions that the replying affidavit should be served upon the prosecution counsel through email, and therefore it's understandable that the prosecution counsel may not have seen the affidavits. It is on record that one of the prosecutors who is alleged to have been served is actually out of the country. That was therefore an oversight on the part of the respondents' counsel. I have gone through the replying affidavits on record. The first respondent's replying affidavit contains 33 paragraphs. The second affidavit, 8 paragraphs. Third and fourth, 8 paragraphs respectively. The fifth respondent's affidavit has 24 paragraphs. The sixth respondent's 45, seventh 24, 8th 41, and 9th 42. Indeed, it would be unfair and not in the interest of justice to expect the prosecution to respond to these total paragraphs of, I think, 200 and something within 15 to 20 minutes as proposed by the defense team. Firstly, the prosecution must sit with the investigators who are the deponents of the affidavits to make a rejoinder to the same. The prosecution only guides investigations and does not participate in the investigations. As much as I agree with Mr. Omari that the DPP is vested with authority or mandate to direct the investigations, it is expected that the DPP, however, must do so in good faith. He cannot, for instance, direct the investigating officer to respond to 232 paragraphs in 20 minutes. Further still, there are affidavits deponed by the respondents in support of the application to cross-examine the investigators. There is therefore quite some work to be done by the prosecution and the investigators, and I'm not persuaded that 15 to 20 minutes is sufficient time. For that reason, I find the application merited. Second issue is whether the respondents should be released on bond bail in the interim period. I would like to state that the prosecution application is brought under Article 49(1)G and 49(1)H, seeking for orders to detain the respondents to enable the investigators to complete investigations. Under Article 49(1)H, the prosecution have sought that the respondents to remain in custody pending completion of the investigations. I am yet to hear that application and the compelling reasons which necessitate the continued detention of the respondents in custody. It would therefore defeat the purpose for which the application was made if at this juncture I release the respondents on bond. It has been argued that the prosecution are enjoying violation of the rights of the respondents. I do not agree with that.
That we are taken date to they argue the application and we defend it. We filed 9 replying affidavits, answering paragraph to paragraph, blow to blow, where we raised very fundamental issues. One, on the contradictions in the state's application. We demanded to have the investigating officers, 2 of them, be cross-examined. The state's objection was not upheld, and the court allowed us that we will cross-examine the people who deponed the investigators. Among the issues that we raised in the replying affidavit that has occasioned this are 13 reasons. 1, the state says all the 9 people were on Mombasa Road during the abduction. We have produced evidence that not all of them were in Mombasa Road. The second respondent was with his wife at home, and we have raised a defense of an alibi. So the state found itself completely flat-footed, alleging that all the 9 people were on Mombasa Road. Number 2, we have produced evidence to the fact that this is a political witch hunt, where the head of state in Kericho Church, the head of state at the national celebrations of Mashujaa Day, directed the police to investigate these people. So we have raised that question, but this is politics, and because it's politics, that is why these people have been arrested and be charged. They have not been arrested because of any other reason other than politics. The third issue we have raised is that the police, the state is asking for 30 days to do investigations. Within the affidavits, the state confirms that they have already done with the phones. They have already done with other facilities. So why are they asking for 30 days? The fourth issue we have raised is the issue about the DNA testing that the state wants. And we have asked, after hiring over 7 pathologists, professional forensic pathologists, who have advised the defense team to ask this question. The DNA that they want to remove from the 9 respondents, where are they taking that DNA to? We will want a sample of those clothes. We will want a sample of those bones. We will want a sample of the bodies before the DNA testing before the DNA samples are picked. Equally, from the advice of the very many pathologists that we have consulted, we have been told that if the DNA samples will be taken, they cannot be taken by the internal affairs unit, which is the one that has brought them to here. We are demanding that if DNA tests to be done, to be taken samples, they be taken, 1, at the national government chemist facilities, and 2, 4 other sample laboratories, 2 of them being outside this country, so that we'll be sure that the samples that have been taken will not be taken and be dumped at Aberdare, and they say these 9 people, their DNA samples have been found at Aberdare. Equally, we have demanded that when the samples, if they will be taken, they 9 will be accompanied by their own independent forensic pathologist, plus government pathologist, so that it is fair and across board. And we are also demanding that the media, the 4th estate, to be present so that it can record the sample taking, because we are apprehensive that the 9 are going to be framed. We have also raised the question about the newspaper story going round that already their phones have been analyzed, and there is connection that the photos of the dead bodies were forwarded to their bosses. We demanded that. Thank God the Director of Public Prosecution yesterday on KTN News denied that that is not the true position. And we wanted to put it very clearly that that is not the true position, that the 9, their photos have been found and the photos of the dead have been ascertained. We also raised the question of why this matter is here, because the abduction happened at Mombasa Road. The courts that have jurisdiction in Mombasa Road is Milimani and Kibera. To the far end of Sid Cabanas, it is Makadara. Why is this matter here? We also raised the question, the bones have been found in Nanyuki, in the Aberdare National Park, which falls under the Nanyuki law courts. Why should these matters be brought here instead of them going to where the offense was allegedly committed, either in Mombasa Road or in Nanyuki? Those matters were weighty. The state could not be able to respond today. Then they made an application that they need 15 days to detain the officers until they respond. We argued over the dates, and the court has made a decision that they will only be given 3 days. Then we will proceed on the application and our responses on Thursday at 9 a.m. Of great concern is that we had raised an issue that the 5 officers who were arrested not to be detained at Industrial Police Station, because some of the people who are inside are the guys our officers arrested. The state objected. We put it to the court that the intention of taking the officers to Industrial Police Station was a sure death sentence for them to be either killed, to be murdered, or to be tortured within the cells. The magistrate went by herself, saw the conditions the officers were, and the court removed the 5 officers and distributed them to Capitol Hill, to Kilimani Police Station, and to Kileleshwa Police Station, which is a confirmation that the officers are being tortured in terms of the investigation. The officers are not getting proper treatment, and we've raised that before the court. Lastly, as I clearly said, I have heard several stories that some of the officers have confessed that they actually were involved in the abduction and killing of the Indians. We want it to be very clear that none of the 9 participated if ever the 2 Indians were kidnapped. None of the 9 was part of it, and that is the reason why none has been charged. Nobody has been charged with a charge sheet. The state wants to detain them to investigate if they were part of that, and we are assuring every Kenyan that none of the 9 officers were part and parcel of that abduction. Of great concern also is why, and we raised this in court, why is there concern of 2 foreigners? There is a Kenyan driver who disappeared. Nobody is following the element of the Kenyan driver. Why is the security apparatus more concerned with foreigners to the exclusion of one of our own, who is a Kenyan taxi driver? So that selective type of prosecution is what we have raised. Thank you. There was an issue. The first 4 were brought under one miscellaneous application, when the next one was brought under a second miscellaneous application. Today, the state made an application for consolidation. We raised an objection that miscellaneous, the first one, the laws they are quoting, they are relying on, are not the same laws that they are relying on in the second miscellaneous application. The state ate humble pie, they apologized, and that matter was settled, and we agreed to amend orally, and the matter proceeded. For now, there is only one consolidated file, that is miscellaneous 256 of 2022, which is the lead counsel. The other file is not there. That has been settled. We objected. Once they changed the law, we accepted for the matter to proceed, and that is already settled. Any other issue?